Welcome, everybody, to Brookings. My name is Jonathan Rausch. I'm a senior fellow in the Governance Studies program. And on my behalf and Paul Edwards' behalf, it is just a tremendous pleasure to have you here today and to have such interesting news to talk about. Paul is the editor of The Deseret News in Salt Lake City, and we are so honored to have Deseret News as the co-sponsors of our event today. This would not have happened if not for conversations that began over a year ago with Paul about how to get involved in this issue in a constructive way. We also have special thanks to the Huntsman Foundation for its support for this event today. We're doing two panels in the kind of time slot we normally reserve for one. And that means time will just fly past, and it also means, as Henry VIII said to Anne Boleyn, I won't be keeping you long. The usual long-winded introductions we will simply dispense with, except to say that, as all of you know if you're here, there was some very big news out of Utah last week, which passed a statewide LGBT anti-discrimination bill, coupled with some rather innovative religious liberty protections. Some people think that could be a national template, which we're exploring today. Our first panel, which Paul Edwards will lead, will look at the news from Utah from people who are in the thick of that conversation. The second one, which I'll lead, will consist of national experts on implications. Each of those panels will be 50 minutes. We'll have some time for Q&A, so get your questions ready. Everybody who's watching this on the webcast, please note that we are taking questions via Twitter, and the Twitter hashtag is, creatively, LGBTLDS. So if you have a question, tweet it to LGBTLDS, and we'll do our best to get it on the stage here. Cell phones off, everybody. It's a courtesy to our panelists. And a word about Paul Edwards, who, apart from being a friend of mine, is editor of The Deseret News, has a PhD from the University of California at Berkeley, and also a law degree from there, but nobody's perfect. Paul, over to you.
Thank you so much. Well, it's a great pleasure to be here. Let me just say a few words about our initial panel here, our panelists. Seated to your right at the end there is Clifford Roski. Cliff is a professor of law at the University of Utah, and he is also the board chair of Equality Utah, which is an advocacy organization that fights for the equal protection and civil rights of LGBT Utahns and their families. Seated next to Cliff, you'll see Mayor Ben McAdams. Ben is mayor of Salt Lake County, which is the jurisdiction that covers most of the Salt Lake City metropolitan area. And relevant to the purposes for today's discussion, I think it's important to be aware that Ben has also been a Democratic state senator in the Utah State Senate, and prior to that was counsel in the Salt Lake City mayor's office. And you'll see with some of the narrative about how things developed in Utah why those positions are important. And then seated right next to me, very glad to have former governor of Utah, Mike Leavitt, who also served in the George W. Bush administration as administrator of the EPA and as Secretary of Health and Human Services. So really wonderful to have you all with us today. So as we get underway here, it would be helpful to ask the question, what was actually accomplished? And I'm going to ask you, Cliff, what was accomplished in Utah with this last legislative session in terms of balancing or protecting religious liberties and LGBT rights?
Well, I do think that most people would agree that the most significant aspect of the law is the addition of sexual orientation and gender identity to Utah's employment and housing anti-discrimination laws. A lot of Americans don't realize that that's not already in federal law. There are 21 or 18 states, depending on how you count it, that protect gay and transgender people from employment and housing discrimination, and Utah is now the most recent one to add those classifications. The law does not include an amendment to our public accommodations laws, so it doesn't regulate whether businesses must serve LGBT customers. I think that was something that both sides were interested in but weren't able to resolve, and we look forward to working on that this very coming year.
Okay. Now, Mike, you were a practicing Latter-day Saint, and you've had significant involvement with public service, to say the least. And I think it's fair to say that since you've left public service, that the leadership of the LDS Church has on occasion sought counsel from you about public affairs. Could you describe your role in working with the leadership of the church?
Well, as you point out, I am not an official of the church, and I am not a spokesman for the church. In our faith community, almost every member has some form of volunteer position, and mine is that on occasion they will ask me for advice on matters related to public affairs, and in that context, I'm at least knowledgeable of the deliberations that they have.
So in your estimation, what actually worked with this past legislative session? Was the church, do you think the church was pleased with the outcome, or?
I think what happened here is that we have seen a great victory for the protection of conscience. I think it is a fundamental belief of, and when I use the word the church in this context, I'm referring to the LDS Church, that you cannot have a society that will be preserved in peace unless you have the protection of conscience. And there was a lot of pain in Utah on both sides of this issue. For many years, there has been a desire to pass a protection for LGBT people. There have been those who have been agitating for greater religious freedom as they've seen this unfold. And what I think occurred was that we saw the church, in this case, step up, not to wield power, but essentially to act as a convener or a healer, to try to bring the sides together to find a place where fairness for all could be presented. And I think that's primarily what has occurred, is that it has matured now to the point that we could begin to look for a solution and the development of a platform for that kind of fairness for all.
Okay, so Ben, let me just ask you, you've been involved with these issues for some time. What has been the immediate result, in your estimation, from what occurred in the legislative session this year?
I think the immediate result is a conversation that's happening in Utah that's very much a healing conversation. Utah's a place that, beginning with Prop 8, and there's been some tension in our local community between our people of the LDS faith and faith generally, and also our LGBT community. And what we've seen happen with the passage of the legislation, but even go back further to the bill's been run now for 7 years, and Salt Lake City adopted non-discrimination protections in 2009. What we've seen happen is really a paradigm shift to a healing dialogue about how can we bring our communities together? What common ground do we have? How can we respect people of conscience and afford human dignity to all of our residents?
Okay, so we've been talking in platitudes at this point. Let me get into some of the specifics. You began your mention here, Ben, with a discussion about Prop 8. Now, last I remember, Prop 8 was a California proposition, not a Utah proposition. And so why does Prop 8 figure so prominently in this narrative? And I'll ask Cliff, why does Prop 8 figure into this narrative about what happened in Utah?
Well, this has a strange personal connection to me. I used to live in San Francisco, and I moved to Salt Lake City in the summer of 2008. And within a few weeks, the LDS Church announced formally that it was joining a coalition of other churches to support the passage of Proposition 8, and therefore the prohibition of same-sex marriage in California. Within, I would say, 2 or 3 months, the Public Affairs Division of the Church began clarifying that while it was opposed to same-sex marriage and same-sex adoption, it was important to clarify that the Church supported non-discrimination protections in employment, housing, inheritance, and health care, which already existed in California. And since I had begun working with Equality Utah, I saw an opportunity there, which is, of course, one of the state's biggest stakeholders, supports several important pressing items on the agenda of the LGBT community.
Okay, so Prop 8, supported by the Church of Jesus Christ of Latter-day Saints. Mike, how did we get from Prop 8 to Senate Bill 296, which is the specific legislation that passed in Utah around anti-discrimination? Is there something about that narrative that you could clarify for us?
I think we should acknowledge, first of all, that there are a couple of things they have in common and a couple that they don't. The first is that the church's position on both were a function of their doctrine. As Cliff pointed out, it is a doctrine of the church that marriage is between one man and one woman. And that's not likely, and that will not change. The second, the 296, is a reflection of the church's belief that Jesus Christ would not abide by mistreatment of others, with the withholding of substance or shelter or employment or care, and that no community should do that either. I alluded to the fact that there was a lot of pain that occurred, that people wanted to resolve this, and that they were feeling this conflict, and it was beginning to have negative impacts otherwise. And I think the church at that point concluded, we can act as a convener. We can act as a healer. Both of these are based on our own doctrine. Let's bring them together and talk. And I think good things happened when that occurred, and that's precisely how we got from Prop 8 to 296.
Okay, so in Utah itself, Ben, you were involved with some of the development of these ideas in the state of Utah. You want to tell us a bit about how specifically then we were moving towards the 296 solution?
Sure. So in 2009, the mayor of Salt Lake City, who I worked for at the time, announced that he was going to propose ordinances protecting against discrimination for Salt Lake City. And immediately we had some very conservative members of the state Senate jump up and say, if Salt Lake City passes these ordinances, we will revoke your ability to enforce these ordinances, which they can do. And that set up, all of us saw from across the political spectrum, that set up a scenario that was a train wreck happening in slow motion, that Salt Lake City would proceed with enacting these protections. The legislature, in anticipation of an election, somebody would run a bill and everybody would feel compelled to vote for it, and we would see this.
Let me probe, in anticipation of an election, why is that important in Utah?
Well, this was politically not popular at the time. So I had a lot of Republican legislators say, I support what Salt Lake City is doing, but if that bill gets proposed, I'm going to feel compelled to vote for the bill.
Okay, now both of you have run for elective office in Utah with great success. And so appealing to the Utah electorate around these issues, just clarify for our audience what that means. What is the makeup of the Utah electorate?
Well, I'm a Democrat in Utah, so I can, but Utah's a
Which makes you about 25% of identified...
Democrats in statewide elections get between 25 and 30%. So
okay.
It's very, very conservative state.
And so yet he holds elective office, yes. So...
So it's a very conservative state, but one of the things that I think, to their credit, both leadership of the church and individuals in the church, but also Equality Utah recognized was that this isn't an easy LGBT versus LDS. These communities in Utah are very much intertwined. Many in our LGBT community grew up Mormon. Many in our LDS faith have loved ones and family members and co-workers who they love and cherish who are LGBT. And so to say that it's easily divided in faith versus LGBT isn't the case in Utah. And I think both organizations recognize, I'm a member of the LDS Church practicing, but also from my very early days in politics, supportive of this non-discrimination protections, recognizing that continuing a war would have casualties on both sides.
Okay, so Cliff, you came in as an outsider, as it were, to this situation in Utah. How did you see this scenario lining up with state legislators trying to appeal to a very conservative base in a caucus nominating system that brings them to office, but seeing what Mayor McAdams is describing as a potential train wreck? What was the role of Equality Utah then in moving the dialogue forward?
So I arrived at an important strategic moment for Equality Utah and a shift that occurred Equality Utah was originally founded in opposition to Utah's Amendment 3, which was a constitutional amendment like Proposition 8 to ban same-sex marriage in Utah. And of course, Equality Utah lost that fight, and Amendment 3 became law. And so now I guess it's 7 years ago at this moment when the church jumps into the Prop 8 campaign, but also says we support employment and housing and other protections. There's obviously an opportunity there to get some things done in Utah, some of the things that would really protect the most vulnerable members of our community. But honestly, the scars, I think, on both sides were still deep. And when Equality Utah saw those statements, I called them up and said, we need to use this. This is a real opportunity. And they said, oh, we're using it. And at the time, they were running what they called the Take the Church at Its Word campaign. They put a clock on the website. It's been 7 days since the LDS Church claimed that it supports anti-discrimination. This is not a productive exercise in Utah. They were running a campaign to repeal Amendment 3 at the time. Of course, we all supported that, but it wasn't going to survive the Utah legislature. And I think we came together and we thought hard about it, and it wasn't an easy decision. We decided we're not going to give up on any of our fundamental principles, but for now, we're going to focus on things that most Utahns agree on and push those very hard. And
this was Equality Utah that came up with,
exactly.
Okay.
And so we called it the Common Ground Campaign, just to emphasize that actually, and polls started coming out, in fact, from the Deseret News and other papers, 75% of Utahns agree on comprehensive anti-discrimination protections. And that's a very powerful signal. And frankly, that's front page news in Utah, certainly. 7 years ago and probably even today.
Yes. Yes, please,
As
Mike.
a person who's observed
Yes.
a few elections, could I comment on this?
Yes.
This is, I think, a national observation I'm going to make. Over the course of the past 20 years, politics has changed. It has been for many decades that if you were to win elections, the idea was hold your base and erode enough from the center that you prevail. Over the course of the past 20 or plus years, that has changed to whoever can light up their base the most tends to win the election. And the consequence of that is that both sides tend to polarize and illuminate very hard lines at the extremes of their position. And consequently, legislation that tends to find its way into the marketplace supports those themes, and it has a zero-sum component. And what I have observed, not just in Utah, but in marketplaces, political marketplaces all over the country, what has been necessary and needful was some kind of legislative tool that allowed those zero-sum games to find their way into a solution. And the question, I think, is, will the marketplace begin to reward solutions as opposed to simply the rhetoric of the zero-sum game? And if there's anything new here, I think, and I believe there is, it is that there is a legislative toolkit now that will be available to those in any jurisdiction to at least begin to say, this is the place, when there's enough pain that will ultimately arrive, why don't we get down to having a conversation about it now?
Okay. And in thinking about the pieces of that toolkit then, what are the specifics in this quote-unquote toolkit that you see as important for the nation? Any of you can respond to that. Cliff, what do you see as specific pieces of the Utah toolkit?
So I think that there's some things that we went into the discussions that were core principles. No specific exemptions that only applied to LGBT people. No exemptions that any religious individual could invoke as a license to discriminate. No sort of Hobby Lobby type exemptions where any business owned by a religious individual or family could exempt themselves from the law. And I think those are principles that I would hope that any local LGBT organization would stick to in these kinds of discussions because they're important. But also recognizing that people of faith deserve the same equal protections under anti-discrimination laws as everyone else. Some of those exist. Maybe some of them need to be refined. And we were certainly open to that. One important piece here, though, is that although it's a milestone, I don't think that it's a model for the following reason. Utah already had pre-existing exemptions for religious institutions in its anti-discrimination laws that are wholly unlike any others in other states or in the federal. For example, religious organizations were completely exempt from our anti-discrimination laws and still are. So churches could discriminate based on race, sex, disability, age, and other characteristics.
Now,
that's unusual.
Was there some additional protection added, though, for religious organizations or religiously oriented organizations in this legislation?
I think the key piece, and unfortunately, I think a lot of the focus on it, the journalism has missed this piece, is there are brand new speech protections for employees outside of the workplace. That's quite significant.
And say a few more words about that, because these aren't just about religious expression. Right. Is that right?
No, so these are based on labor laws in many other states, which contain similar speech protections. But what they say is, if you engage in religious, political, or really any other kind of speech outside of the workplace, for example, if you donated to support Proposition 8 or you donated against Proposition 8, your employer can't fire you when you come back to work for that donation. There are, of course, some reasonable limits placed on those laws, but it's essentially a labor law, which is a speech protection that provides equal protection for religious and non-religious speech. And that's quite significant. That's a clear win-win in this conversation.
Okay, and I do think, and we'll leave some of this terrain for the next panel, but I think important to recognize that one of the issues that may come up in a structural framework for people that are looking at this as a potential model would be that, are we looking at particular carve-outs in the law to make this all work, or are we looking for broad equal protection principles that will make this work? And this one passage in the law about speech is one of the equal protection kinds of pieces that finds its way into what ended up to be the compromise. There are some other important quote-unquote carve-outs or special protections in some of the other pieces of legislation.
Can I follow on, Cliff? Utah is one of 50 states. There are thousands of jurisdictions who are having this conversation in one way or another. So I think Cliff's right. Every conversation will be unique unto itself. But there is, I think, the making of a model in the pathway. There is a rhythm about legislation that typically this occurs, particularly in the political marketplace as we know it. Each side starts off with a zero-sum game and a piece of legislation that they're for and one that they're against. And they tend to look for ways in which they can overcome the other. The unique part here is to acknowledge that if this is going to happen, it has to happen at the same time, because the other side will not trust that you'll come back and protect them later. It has to happen simultaneously. And I think that's a key element of the secret sauce here, is moving to meet the needs of both simultaneously.
Now, I think there are going to be some important questions from the audience here. Before we turn to that, I do want to ask Ben if you would say a few words about how that trust was built up over time. And if there are any lessons to be learned from the Utah experience, and again, from, throughout this last decade as we've wrestled with these issues as a community.
Yeah, that trust, was built up over time. It wasn't just coincidence that 2 months ago the LGBT community and the church came together and had a dialogue, but dating back to 2009 when these conversations started around a Salt Lake City protection. But there was the executive director of Equality Utah at the time, Brandy Balkin, who was a real hero, no longer the executive director, but a real hero in this process. She developed great relationships with church public affairs and church leadership, and they really developed a fondness and trust for her. I remember an experience, if I might share, where there was a gay rights group that was planning a protest right in front of the church headquarters. And I remember hearing the story. I don't remember who told me, whether it was Equality Utah or officials from the church, but that the church said, "Hey, we've been great to work with. Are you really organizing a massive protest in front of our headquarters?" And great to work with, meaning there's dialogue, not to say that Equality Utah was content with the status of where things were. But Brandy said, "You know what? In a show of faith, you're right. I'm going to reach out to this organization. We're going to move that protest as a rally in front of the Pride Center." And just that token of, yeah, we're not going to protest you. We're going to rally. We care about rights, and we care about an agenda that we're looking to move forward. But that can happen constructively at the Pride Center and not destructively in front of church headquarters. And so it's things like that that happen from both sides. That the LDS Church, I think, then reciprocated by inviting gay rights organizers to a holiday music festival. And they were treated as VIPs and seated very prominently, and that happened over time. Now, it didn't just happen when people decided to come together and draft a bill, but there were gestures, healing gestures to bring the two sides together to say, we've got more in common, that my constituents are your constituents, and vice versa. And that happened over time.
Okay. Well, we'd love to hear your questions from the audience. Yes, back here.
My name is Stephen.
Introduce yourselves.
My name is Stephen Shore. You've said that.
And are you with an organization or just?
Just as an individual.
Okay.
That, of course, the doctrine, as we all know, of LDS is that marriage is between one man and one woman, but it's not a secret that under Joseph Smith and Brigham Young, that the doctrine was of one man and a goodly number of women. So how certain are you that the church will not, in the fullness of time, change its doctrine?
Okay. Mike, you've had close connections with some of the leadership of the church.
Well, I am not a spokesman for the church. I'm not an officer of the church. I want to make that clear. As you might point out, I've been able to observe this. I think that the doctrine of the church is as it is and as it will remain. Marriage is between one man and one woman. But I also think it's important to acknowledge this. There is a narrative often about the church that I just think is fundamentally wrong. I mean, the Church of Jesus Christ of Latter-day Saints has 15 million members. It has status in 195 countries. It operates under governments that are communist, monarchies, and democracies. It has members as diverse as Harry Reid and Orrin Hatch, both who can stand on the floor of the United States Senate and debate the opposite sides of this issue, and at the same moment, both be considered very good practicing members of the church. What they have in common is a belief in the gospel of Jesus Christ and some commitments that they have made. So as we begin to think about these issues, it's important to recognize not just that doctrine, but the broader doctrine that unites them and the reason that they're together as one faith.
Okay. Other questions? Yes. And again, if you can wait for the microphone and let us know who you are and if you're representing anyone today.
Yes, I'm Peter Sprigg, representing the Family Research Council. I read the text of the bill, SB 296, and it contains quite elaborate enforcement mechanisms for the non-discrimination provisions. But the free speech religious protections are not accompanied by any particular enforcement mechanism. And I wondered, that struck me as a weakness. I didn't know if it is implicit that the violation of those protections is religious discrimination and thus subject to the same enforcement protections as the sexual orientation and gender identity, or should there not be other enforcement mechanisms for those protections?
Hey, Cliff, enforcement issues around the very clause that we were talking about.
Honestly, I don't think that the issue is particularly clear in the bill. It's an insightful question. I will say that Utah's Employment and Housing Code are both enforced by the Utah Labor Commission through administrative proceedings. So I would expect that if someone raised a complaint under those sections, that they would have to, like anyone else, file their complaint with the Utah Labor Commission, who would appear before an administrative law judge to enforce them. What the remedies would be, I would imagine, would be up to the judge in the particular case.
Okay. There have been, interestingly, critiques from other religious organizations or spokespeople for religious organizations, for some conservative groups, that this was a very well-intentioned piece of legislation on the part of what the LDS Church did in making its initial move, but naive because they gave up too much. How is this a fair critique from the religious right?
I think we can expect that I don't mean to imply this to one or the other, but if organizations have been accustomed to focusing on the sort of zero-sum approach to this, that this will seem as though it's different, and they will not see it as a model, and they will not see it as anything that will be replicated. Time will tell that. I would just suggest that there's a lot of pain, not just in Utah. There's a lot of pain everywhere. And people are looking for a solution to this. And we have this dilemma, and that is that if suddenly we conclude that religion is simply an excuse to discriminate and we ought to protect people from it, or we conclude that LGBT people ought not to have rights, either one of those are unacceptable to the American people. And if we continue to speak about them in those terms, no solution will be found. The pain will get bigger. And what I said earlier, no nation can continue in peace unless conscience is preserved. The American people are ultimately going to require that we find a place where both points of view can reside and that we can move on as Americans. And it will naturally lead people to look for a place to solve it. And what we see here isn't a bill that's going to solve all the problems. This does not get into public accommodation. No. Why? Well, that may be the next question. I'll give my answer now.
Okay.
It's because it couldn't legislatively be done. There wasn't agreement. There will be other things, like has been mentioned, that still need to be worked through. What we're working toward here, though, is that we're looking for a way now to solve this problem.
Okay, Cliff, but you've also received criticism from another flank as well, right? That this didn't go far enough, that this didn't accomplish enough for the LGBT community in Utah. What's your response to that critique?
Well, honestly, looking at a lot of the criticism, what I've seen is that actually the law that we all wrote together is quite a complicated thing. And because of the unique history of Utah and its broad pre-existing exemptions for religious organizations, a lot of the criticism is blaming this law for things that already existed before it. So folks are saying that we traded basic protections for LGBT people in exchange for sweeping, unprecedented exemptions for religious organizations. Those exemptions have always existed in Utah law because of its history. It was founded by a church. So a lot of it seems to be based on understandable both mistrust and misunderstanding. It is hard to believe that the Utah legislature would pass a law that protects LGBT people and offers truly equal protections for that community and for people of faith. And so I think as people get to know the details of the law and what it actually did and didn't do in Utah, I think they'll come to see that it's a good development.
Yes, back here.
Hello, I'm Jennifer Kamborian, and I'm here just as a private citizen. Governor Leavitt, you mentioned something that I caught my attention. You said that a lot of the politicians and the political parties tend to try to light up their base by polarizing the issues in order to get elected or to pass the legislation, which is understandable. And it appears, too, that the press, the modern press especially, has really contributed to that, because in order for them to get the attention that they want, the readers that they are seeking and the viewers, they, of course, to contribute to that polarization of the issues. What can the regular citizen like myself, the housewife from Oakton, what can we do? I care very much about this issue, and I care very much, and my friends care very much about finding a middle ground where both interests can be served. What can those of us who are not in the press, who are not in the media, and who are not in politics, what can we do to participate in this process and to help to find a more moderate, inclusive, less polarized type of legislation, and to find leaders that aren't so polarizing? And how can we not be drowned out by these loud, more powerful voices?
Thank you. Mike? And actually, let's also ask Ben an elected Democratic official from Utah. But Mike, go ahead.
Well, I would just agree with your observation. The media is a marketplace, and who understand that they're looking to create an audience, and hence they have begun to speak in cohorts as well. And so you end up with Fox versus MSNBC, and people who like to hear Fox News go there, and people who like to hear MSNBC go there. And consequently, we don't have a cable channel that's dedicated to finding a solution like this. And I would just say being involved in the public square with your voice is the most important and likely the only thing that any of us can do. What we need to make certain of is that all voices are protected and respected in the public square, that there's fairness for all.
Ben, any thoughts on this?
Yeah, I would add, I'm deeply committed to my faith. And that deep commitment to my faith leads me to support basic rights and human dignity for people in our LGBT community. And I think the most important thing that can happen is for everyday citizens like yourself to be who you are, but be somebody who respects, loves, and cherishes somebody who's different than you. And I think that's what's happened and is happening in Utah, and I think around the country, is that we are finding that common ground, because we're finding out that our coworker is gay, and that he's actually a pretty good guy and a pretty good coworker, and that's okay. And we're seeing this reconciliation of family love and family relationships that's happening around the country and is happening in Utah. And that's what I'm proud of that has happened with the passage of this non-discrimination protection, is it's a statement that my deeply held convictions are not incompatible with my coworker whose family life is different than mine.
Okay. Other questions from the audience. I have one about the role of Kitchen v. Herbert. So as we've talked about some of the narrative moving along here, there was a very important case decided in December of 2013 that somewhat stunned the state, I think, although it had been through the process of litigation. How does the Kitchen v. Herbert case, if someone could, Cliff, could you describe what that did in the state of Utah and why it was somewhat, just describe the holding of the case and why it was important in this narrative?
So Kitchen v. Herbert was the first federal court ruling that struck down a state's ban on same-sex marriage after the Supreme Court had struck down the Federal Defense of Marriage Act. It had its obvious shock value as not only the first, but in Salt Lake City, Utah. Many people think that everyone in Utah is LDS conservative Republican. The idea that a judge would strike down a marriage ban seemed to signal the way things were going to go after the fall of DOMA. And then there was a slight wrinkle that made it particularly compelling, which was the Attorney General had neglected to request a stay of the ruling, and therefore same-sex couples immediately rushed down to county clerk's offices all around Utah, and the sort of pent-up demand for marriage that had built up over years. People were getting married as a very festive occasion at many county clerk's offices. And so that obviously put Utah front and center once again in the question of same-sex marriage. And also really just showed, well, that same-sex marriage can come to Utah, and after it's there, things are much like they were before. I think that actually many people's friends and family were in the county clerk's office, and so the conversation took a different turn at that point.
And I, from my observation, in that fall of 2013, there was actually starting to be, again, some discussion about the potential for a grand bargain on this issue of how to balance potential challenges to certain religious freedoms and the importance of anti-discrimination legislation statewide. I do think that Kitchen v. Herbert put a pause in those discussions and may have stopped for a period of time getting to this particular moment.
Can I comment briefly on this? Not so much the specifics of it, but I think what it illustrates, and this is something that every faith community has to come to, I think, appreciate, and that is we live in our country in a democracy, and that the instruments of democracy will decide what the government will protect and what the society will value. Churches, on the other hand, have the ability to decide what their doctrine will be. The brilliance of the American government is that we have allowed that decision on doctrine to be separate from that which we've allowed them to exist simultaneously, and that has allowed conscience to be protected. Back to my point that if there's ever a point when conscience is not protected, then the security and the capacity for that society to exist in peace will go away. And so that's the reason I think this is so important, is that we've acknowledged the role of both of them.
Okay. I just, as we're coming towards the end of our panel here, I do want to express my deep appreciation to the Brookings Institution for working with the Deseret News on hosting this. As Jonathan Rausch noted at the beginning, Jonathan and I have been having discussions for a period of time about the promise and perils associated with religious exemptions in this anti-discrimination environment. And I think, I can't speak entirely for Jonathan here, but I think we share an intellectual belief, a kind of a distaste for the judicialization of policy making that can happen, where you end up with a winner-takes-all kind of approach. And I think one of the things that we're seeing demonstrated in this kind of a discussion is that, there really is an opportunity for the promise of Madisonian democracy to work quite well. That is, if you have well-designed democratic institutions and well-functioning civil society, that you can get to a decent and self-governing pluralistic blessedly pluralistic society. So really grateful to be able to work with Jonathan on pushing that kind of a discussion forward. I also just want to acknowledge the great support of two great American philanthropists, Karen and John Huntsman, who also made today's event possible. So we probably have time for one or two more questions from the audience. Yes, right here.
Craig Howell, speaking for myself. I just heard something I'd like to get clarification on. Most laws have a severability clause that says if one provision of this law is thrown out, the rest of the law remains standing. Am I to understand that there's no such language in this bill, so that if one part of this compromise falls apart, the whole thing falls apart, thereby giving an incentive to both sides not to challenge?
Cliff?
Yes, there is a non-severability.
Why non-severability?
Some stakeholders apparently wanted to make sure that, as you said, if any part of the law were challenged in court, then the entire law would have to be struck down and the negotiations or discussions would have to begin again.
In fact, the bill itself says this has been an effort to find a balance between these 2 points of view, and therefore taking one out and leaving the other would, in fact, destroy that balance. So it's not only there, it's explicitly explained in the language of the bill.
Yeah, that is unique, right? So it does give this specific mention that because this was an effort to deal comprehensively with the issues, it needed to be non-severable. Now, one thing I think should also be noted is that I think we've talked a lot about 296. That's the bill that deals with an amendment to the anti-discrimination laws in the state of Utah. There was other legislation, and this may be a part of the next panel, that dealt with issues related to solemnization of marriages in the state, who could do that, who could opt out of that, including whether or not government officials might have some choice. That bill did not have a severability piece to it, although it did note that it was related to the overall legislative package. There were other kinds of interesting protections passed in trying to deal with same-sex marriage coming to the state and concerns about what families might be able to do in terms of teaching about human sexuality within their homes. So there was another piece of legislation passed that was seen by some as an important part of the religious conscience protections for families that simply codified and clarified an existing state regulation about parents' ability to opt their children in or out of human sexuality teaching within the public schools. So there was a lot of work going on around these measures. Another question, and then we'll probably have to conclude this panel. Well, with no other questions from the audience, let me oh, I missed it. In the very back, yes.
Hi, thank you. I'm Maggie Gallagher. I'm just here representing myself, but I'm thinking about writing for National Review. And I just, first of all, want to thank Professor Rodsky for pulling out the protections for non-workplace speech. And I do think that the question of whether those are substantive or decorative, which maybe we can't answer now, is going to affect the way a lot of people who oppose same-sex marriage or who are members of traditional religious communities are going to perceive the bargain. But I wanted to ask Ben McAdams, and this is related again to the difficulty of getting to a better place, because I think gay people feel quite reasonably that they grew up in an environment where they were repressed, oppressed, stigmatized, and marginalized. And I think it's hard to give credit as real to the growing sense among traditional believers that it's hard to make a livelihood if you're known to not believe in gay marriage. And so my question for you is, since this is under your jurisdiction, do you think it's right for the Salt Lake City Police to discipline a police officer merely for requesting a religious accommodation? Because to us, it kind of feels like, okay, you put these religious accommodations in, and then if we try to use them, we get flagged as traditional believers, and then we get punished. So I don't know if you have anything. I know you may not be able to speak about the specific case.
Yeah, no, I'm happy to, both as a mayor, but let me start with maybe a little bit of background. After I had worked,
and we'll have to keep this brief to move to the next panel. So.
When I worked for Salt Lake City, and we passed the non-discrimination ordinances in 2009, and then I ran for the state senate. I remember talking to a law colleague of mine at the time who said, I told him I was running for the state senate, and I practice law in New York, so I was talking to a Jewish friend of mine out of New York City, and he said, so tell me kind of the strengths and weaknesses of your campaign. And I said, we had talked for a little while, and he said, so let me summarize this. The biggest weaknesses to your candidacy are the fact that you're straight, married, and Mormon, because I represent a very liberal part of Salt Lake City. And he said, I clearly don't understand Utah like I thought I did. And I would start with that. I think many throughout the country don't understand Utah like they think they may. To put us into stereotypes and to cliches, you don't understand Utah, and I think this clearly is evidence of that. On the night that this legislation passed, Senate Bill 296 passed the House, I took my 9-year-old daughter to watch the debate and to see the vote. She was happy because it was a school night and she got to stay out late. But what a proud moment for Utah that we showed the country that respect and human dignity for our LGBT neighbors is not inconsistent with our faith. And I was very proud about that. Salt Lake City, I'm the mayor of Salt Lake County, so the instance you cite is not within my jurisdiction, but I feel very strongly that as a servant of the people of Utah, that I will uphold my duty without question and without discrimination, and that's something I feel strongly about.
Okay, and I'm sorry we don't, Maggie, I'm sorry we don't have time to get into the very specifics of this case, but it did become part of the discussion in the passage of the legislation in Utah about a particular case involving a Salt Lake City police officer and what his particular role was in a gay pride parade being asked to do, and could he receive an exemption. And so thank you for the question. As we wrap up, What would you like to see? What's left undone? What needs to be done next? Mike?
I think the fact that we all recognize more needs to be done. We're going to see the questions related to public accommodation continue to be discussed. We're going to continue to see litigation on small business and large business and individuals. This was not comprehensive, but it did create a pathway, I think, and it did begin to create a construct.
Okay, Ben?
I think we need to continue to build trust, that this dialogue is the start of a dialogue in our community, but bringing back people from our LGBT community are coming back to faith, and that's wonderful, and faith is coming to our LGBT community. And then in the civic dialogue, we need to promote one of understanding and mutual respect.
Cliff?
In addition to public accommodations, there's a real opportunity on hate crimes legislation. Utah really has, frankly, a fairly terrible hate crimes piece of legislation. There was recently an attack against 2 gay men in Salt Lake City, and the district attorney wanted to charge it as a hate crime, but he couldn't because of what the legislature had done, frankly, to prevent sexual orientation from being included in the state's hate crimes law. That's something where I really think the religious liberties issue we're all against hate, and we're all against hate crime. So I think it's a much easier issue to tackle, but of course, fully committed to working on public accommodations.
Okay. Will you join me in thanking our panelists for what I think has been a very informative discussion? Thank you.
Thank you.